What are you doing?
Hello, how are you doing?
What are you doing? Get out of the car.
Okay, I'll get
No,
on.
get out of the car.
I'm sorry, I was just trying to park.
Give me your phone.
Get out of the car, ma'am.
Get out of the car. No, you're not trying to park. I've been following you everywhere. Turn around. Stop.
On the night of April 4th, 2024, a Georgia police officer attempted to pull over a vehicle for speeding. The driver failed to stop circling an apartment complex before finally parking. What began as a routine traffic enforcement encounter would escalate into a DUI investigation, an arrest, and a lesson in how quickly a minor traffic violation can compound into a criminal conviction. This is the body-worn camera footage that follows. Officer Tyler makes initial contact at the driver's window. The subject is already parked, but refuses to exit the vehicle. Under Pennsylvania versus Mimms, officers conducting a lawful traffic stop may order the driver out of the vehicle as a matter of course. No additional justification required. The subject's initial resistance to that command, while understandable given her stated fear of police, nonetheless represented a failure to comply with a lawful order. Officers physically direct the subject out of the vehicle and place her in handcuffs. 5 officers are on scene for a single occupant vehicle, a number the subject herself questions. While this may appear disproportionate, it is consistent with protocol when a vehicle fails to yield to emergency lights and the occupants are unknown. Additional units are appropriate. The subject was not identified prior to the stop, and officer safety considerations justified the response.
I'm going to read you your rights. You do have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one can be appointed to you at government expenses.
The officer reads Miranda rights immediately after handcuffing and before any substantive questioning. This timing is legally significant. Under Berkemer versus McCarty, roadside questioning during a non-custodial traffic encounter does not require Miranda. However, once the subject was physically restrained in handcuffs, a reasonable person would not have felt free to leave establishing custody and triggering Miranda's protections. The advisement here is timely and complete. A second officer, a DUI specialist, takes over the investigation. The tone shifts noticeably. The DUI officer's approach is conversational, even empathetic. She asks where the subject is coming from, establishing a baseline of behavior and drawing out voluntary admissions. The subject discloses she had been on the phone with a coworker and went to Taco Bell. Then, unprompted, she begins explaining why she did not stop. Her stated reason, fear of police, rooted in her mother's prior arrest. This is not a legal justification for failure to yield, but it is important context for the grading analysis.
100%. I know 100% why I was being pulled over is because I was speeding, and I know I was speeding.
Under Georgia Code Section 4674, a driver who fails to yield to an authorized emergency vehicle displaying lights and sirens commits a misdemeanor. The subject acknowledges she saw the blue lights and knew their meaning. She admits she was speeding and chose not to stop out of fear. Those admissions establish the elements of the charge. However, as the outcome will show, this charge was ultimately dismissed, likely as part of a plea negotiation on the more serious DUI charges. The DUI officer pivots to the alcohol question. The subject answers voluntarily and honestly. She consumed approximately half a bottle of red wine, roughly 1 to 1.5 hours earlier, accompanied by food. She assesses herself as safe to drive. This voluntary disclosure is notable. The subject had the right to remain silent under Miranda. Every statement she makes here is potentially admissible. The officer asks whether this amount is normal for the subject, who confirms half a bottle is typical, meaning her tolerance may be higher than average, which courts can consider in a less safe DUI analysis under Section 46391, subsection A1. The officer conducts the horizontal gaze nystagmus test, the first of 3 standardized field sobriety tests developed by the National Highway Traffic Safety Administration. HGN measures involuntary jerking of the eyeball, a phenomenon that increases with alcohol consumption. An officer trained in this protocol checks 6 clues across both eyes. lack of smooth pursuit, distinct nystagmus at maximum deviation, and onset of nystagmus prior to 45 degrees. 4 or more clues indicate a BAC of 0.08 or higher with approximately 77% accuracy, according to NHTSA validation studies. The subject cooperates fully, though she notes she is shaking from the cold. The horizontal gaze nystagmus test is widely accepted in Georgia courts as scientific evidence of impairment, though the officer's certification level and administration method will be scrutinized in any contested hearing. The test is not infallible. Certain medical conditions, medications, and neurological factors can produce nystagmus in sober individuals. The DUI officer noted she had concerns after examining the subject's eyes. The language she used at the scene, consistent with observing multiple clues.
I'm shaking. It's cold.
The officer proceeds to the walk and turn, a divided attention test requiring the subject to follow multi-step instructions while walking heel to toe along a line. Officers look for 8 clues. Inability to maintain the instruction stance, starting too soon, stopping while walking, missing heel-to-toe contact, stepping off the line, using arms for balance, making an improper turn, and taking the incorrect number of steps. 2 or more clues indicate impairment. The subject performs the first pass without counting aloud, a clue in itself, before self-correcting on the return. The officer does not explicitly call the clues on camera, but observational documentation would be completed in the arrest report. The final standardized test is the one-leg stand, 30 seconds of balance on one foot while counting aloud. Officers watch for swaying, using arms for balance, hopping, or putting the foot down before 30 seconds. 2 or more clues indicate impairment. The subject performs notably well, invoking her cheerleading background. The DUI officer acknowledges this directly. You have really good balance with that. This is an important moment. Rather than inflating observations, the officer objectively credits the subject's performance. This type of fair witness conduct supports the officer's overall credibility when the arrest decision is later reviewed by a court.
You are being placed under arrest for driving under the influence. Do you have any questions for me?
The subject immediately challenges the arrest. She has not yet taken a breathalyzer test.
So we're not at that point.
The officer's response is legally accurate. In Georgia, the arrest decision in a DUI case is made based on the totality of observable evidence, driving pattern, physical appearance, field sobriety performance, and admissions. The breathalyzer comes after the arrest decision and is governed by the implied consent law. The officer then reads the Georgia Implied Consent Advisory verbatim, a statutory requirement under Official Code of Georgia Annotated, Section 4567.1. Any deviation from the prescribed language could render the results inadmissible. Under Georgia's implied consent law, any person who operates a motor vehicle on Georgia roads is deemed to have consented to chemical testing of blood, breath, or urine if arrested for DUI. Refusal to submit does not prevent arrest, but it triggers an automatic 1-year license suspension, and the refusal itself may be introduced as evidence at trial. The subject asks about the consequences and the process before agreeing. Her consent was not unequivocal. She expressed hesitation and concern about having no one to pick her up from the station, but ultimately, she said yes. A court would likely find this voluntary consent. During transport and waiting at the station, the subject remains remarkably cooperative and conversational. She discloses a prior breathalyzer encounter at age 19 in Ringgold, Georgia, during which she was not arrested. She self-describes as a habitual speeder without prior tickets and estimates she drinks approximately 3 times per week. Each of these voluntary statements is potentially relevant. A prior DUI adjacent stop could be relevant to a prosecutor's sentencing argument. Frequency of alcohol consumption speaks to tolerance and behavioral pattern. None of these disclosures are coerced. They are volunteered. This illustrates a common mistake. The time after arrest but before processing is not a safe time to speak freely. The DUI officer administers the intoxilyzer breath test, Georgia's approved evidential breath testing instrument. 2 samples are required for a valid test, with results within a specified variance of each other.
Keep blowing, keep blowing.
The officer provides clear instruction. A deep breath, blowing as long as possible. The subject cooperates fully with both samples. The officer explains that a larger breath sample benefits the subject by providing more complete data.
A little bit more.
Both samples return identical results. Both breath samples return a blood alcohol concentration of 0.123 grams per 210 liters of breath. The legal limit under Georgia Code Section 46391 is 0.08. The subject's BAC is approximately 1.5 times the legal limit, consistent with the officer's on-scene estimate. Importantly, the identical readings across both samples eliminate the possibility of a machine variance challenge. This result supports both the DUI per se charge under subsection A5 and the less safe DUI under subsection A1.
So we took 2 samples and you blew the exact same for both. So there's not a lower number really. So the legal limit is 0.08 and you did a 1, 2, 3 for both. Okay. So you're a little over the, almost, let's say 1.5 over the legal limit, okay?
The subject is transported to the jail for processing. Her practical concerns, no one to release her from custody. Her apartment nearby are acknowledged by the officer, but cannot alter the legal process now underway. The officer's handling of this transition is professional. She is direct about consequences, while remaining composed and courteous. The subject, for her part, continues to cooperate fully. The investigation concludes with 2 confirmed breath samples, a complete set of field sobriety observations, and multiple voluntary admissions. A legally robust DUI case. Following transport to the jail, the subject was charged with 4 offenses. DUI, under the influence of alcohol. DUI per se for a BAC above 0.08. Speeding, and failure to yield to an emergency vehicle. At disposition, she entered a guilty plea to DUI alcohol, DUI per se, and speeding. The failure to yield charge was dismissed, a common outcome in plea agreements where more serious charges carry forward. No further information regarding sentence specifics was available at the time of this analysis. The DUI officer receives an A-. Her investigation was methodical, legally compliant, and notably professional from start to finish. She administered all 3 standardized field sobriety tests in sequence, provided clear pre-test instructions, and critically, accurately reported the subject's strong performance on the one-leg stand, rather than inflating clue counts. Her reading of both the Miranda warning and the Georgia Implied Consent Advisory was timely, complete, and verbatim delivered at precisely the moments the law requires. The sole area of concern is the improvised restraint officers discussed using a chain due to the subject's small wrists, suggesting standard equipment was not adequate. While not a legal violation, it raises minor documentation and equipment readiness questions. No significant legal or tactical errors were observed. The subject receives a C+. Her cooperative, honest, and non-combative conduct was a genuine credit throughout the encounter. She did not resist, she consented to every test, and she remained emotionally controlled under significant stress. However, her decision-making across the arc of the night created and then compounded her legal exposure in largely avoidable ways. She drove with a BAC of 0.123. She failed to yield to emergency lights despite acknowledging she saw them and understood their meaning. And after receiving Miranda rights, she continued to speak at length, disclosing prior police contact, weekly drinking habits, and her own assessment of her sobriety. None of that information was required. All of it was potentially usable against her. Cooperation and silence are not mutually exclusive, but she chose cooperation over silence at every turn. Before we go, here are a few takeaways from this case. 1. Failing to yield to emergency lights is a separate criminal charge. Fear of police is not a legal defense. If being pulled over makes you anxious, the safest place to handle that anxiety is pulled over at the side of the road. 2 Miranda rights protect the right to remain silent, and silence is most valuable in the minutes after an arrest, not before. Volunteering your drinking history, prior police encounters, and weekly habits is not required and can only hurt you. 3 field sobriety tests are voluntary in most states, but declining them is not consequence-free. A refusal may be noted in a DUI report and interpreted by a jury. Knowing your state's specific rules before you are ever in that situation matters. 4. Georgia's implied consent law means that driving in the state is treated as advance consent to chemical testing if arrested for DUI. Refusing the breathalyzer does not prevent arrest. It guarantees a 1-year license suspension and can be used as evidence against you at trial. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. If you found this analysis useful, make sure to subscribe and hit the notification bell so you don't miss our next case breakdown. Thank you for watching.